This is a CBC News special presentation.
Good evening, I'm Andrew Chang. COVID-19 changed our lives, and it changed death in this country too. Medical assistance in dying, known as MAID, was affected. Some hospitals temporarily restricted services. PPE and physical distancing made procedures harder, and the presence of family members was limited. These are all layers on what was already a complex, deeply personal issue. Now, early this year, before the pandemic, we invited a group of Canadians to put their questions to a panel of experts, including the Minister of Justice, David Lametti, about who has access to MAID and who doesn't. Here now is the national conversation.
Today I'm feeling angry.
Today I'm feeling concerned.
Conflicted.
Hopeful.
This is complicated.
In the days and weeks and months before the COVID-19 pandemic hit, another public health discussion was happening in this country, one of life and death, specifically medical assistance in dying, or MAID. In the last 4 years, more than 13,000 people have chosen to end their lives that way, but it affects so many more. When a Quebec court decision forced the federal government to change the law, it launched online consultations back in January. And in 2 weeks, more than 300,000 Canadians responded. Part of what emerged, a list of proposed changes from the government affecting who is eligible and when.
We are talking about people who are suffering.
To qualify for medical assistance in dying, a person would still need to be suffering from a serious, incurable illness, disease, or disability, but no longer would their death otherwise need to be reasonably foreseeable. And no longer would they always have to give final consent at the moment their life is to end, which was a worry for those who feared they might lose that ability as their illness got worse and worse.
We must act responsibly and, most importantly, with compassion.
The legislation is now before Parliament, and a full review of the law was scheduled for June. When the pandemic hit, that review moved to December. But still, Canadians continue to have questions.
I need to ask this.
This is difficult.
This is complicated.
This is personal.
We put those questions to the experts as part of the national conversation. Welcome to the National Studio in Toronto. Canadians have said just how important this issue of medical assistance in dying is to them. So tonight, we want to know what you think about it. Hello, I'm Andrew Chang. This is a complex, a deeply personal issue as well for many of you from across this country. It touches so many people, so many families. Many of those here with us tonight have personal experiences with medically assisted dying, whether they are health professionals or they or their loved ones are considering it as an option. Like many of you at home, they have questions. So this is an important conversation, a hard one as well, and we want to help as many people as we can through it. So joining me today, Federal Justice Minister David Lametti. Trudeau Lemons is a bioethics expert and law professor at the University of Toronto. Dr. Madeleine Lee is a psychiatrist working in end-of-life care. And Susan Desjardins is with Dying with Dignity. That's a patient rights group. Thank you to all of you for being here. Let's get to our first question. Judy, the floor is yours.
I watched my mother die a slow, painful death. My brother and I were the power of attorneys, and we were able to stop food, stop water, stop her oxygen. But I couldn't stop her suffering. So my question is, will or when will the MAID be available to a power of attorney to make those decisions?
Thank you for the question. I understand what you went through, having gone through a similar thing with my mother. Power of attorney is delegating decision-making, and that's something that we will look at with respect to advance requests in the summer review, and looking at in particular situations of cognitive mental decline, like dementia. For the time being, the law focuses on the individual's consent, so the individual making a choice. We still aren't at the stage where power of attorney will be able to be used. But it is something that could be considered down the road as part of that larger review.
Why is it any different where a person can make the choice to withdraw life support versus making the choice to administer MAID? They accomplish the same thing, except one is slower and one is more
One
painful.
ends suffering and one doesn't.
Right.
One extends it.
I think we're all trying to eliminate or reduce suffering where we can, and I think that's one of the things that's certainly motivating me in pushing forth this legislation. There have been a number of traditional medical doctrines and religious doctrines too that distinguish between withdrawing treatment or withholding treatment under certain circumstances and actually actively doing something to end a person's life. And so these are ethically charged issues. These are, they're complex. And so these are questions we will look at, but they're not easy. They're really not easy.
Judy, thanks very much for your question. Appreciate it. Our next question comes from Justine Noel. I want you to have a look at this.
Hi, my name is Justine Noel. I'm 29 years old, and I would be looking to access medical assistance in dying at some point in the near future, if I'm approved. I've lived with chronic pain my whole life, but it really got debilitating around 18, at which point the idea of fibromyalgia started getting floated around by doctors. I can't work, I can't have fun, I can't barely leave the house. So far I've had 3 MAID assessments. The first 2 were denials and the third one is pending an official answer. None of them were experts in my condition. I haven't met any fibromyalgia specialists who support MAID for fibro patients. Because the people who spent their whole lives working on this, what they're gonna say is just keep waiting. Just keep waiting for a cure to be invented. But I can't wait for much longer.
Justine can't be here today, but her partner, Jason, is here in her stead on her behalf. Jason, thank you for being here.
Thank you.
What's your question?
What do you intend to do when there is not a MAID assessor who is an expert in the patient's condition?
So thank you, Jason. Thank you, Justine. The question is a good one, and I'm glad you asked it. The expert assessment is not, we're not requiring a specialist. We heard from people in the consultations, particularly from remote communities, that felt this might become a barrier if we required a specialist. Rather, it is somebody with some level of expertise in the condition. You know, there are 2 medical assessors who are looking into the file. Hopefully one of them will have access to a network of people. Again, it doesn't have to be a specialist.
Jason, it seems like you want to.
Yeah, I'm sorry. I don't want to be rude or interrupt.
Yeah.
From my perspective, I think the best expert in a patient's condition is the patient. And to put the decision on the shoulders of someone who doesn't necessarily have a thorough knowledge of their medical background or the suffering that this person has gone through, I don't understand why you've made this a requirement.
Madeline, maybe if I could have you weigh in on that. I mean, in practice, do you see this as being such an onerous requirement that it actually ends up hindering the process?
I was glad to have it clarified that it is expertise and not a specialist that's required, because I think that would be onerous and a real barrier if you required a specialist to be a MAID assessor. So for something like fibromyalgia, there isn't even really a specialist that you can name. The fibromyalgia patients often have rheumatologists and psychiatrists and neurologists and pain specialists, you know, multiple doctors involved. So who is the expert in that?
Well, my perspective is that with this criteria, even with the proposed amendments, you're still not giving the patient the ability to say for themselves, can I have a medically assisted death? The government is still saying, well, hold up, no, you can't.
But there is a reason for that. You have to understand that medical aid in dying is a radical departure from normal treatment. So it means the end of the existence of the person. If there are chances for the person who wants to have medical aid in dying to get better, we really want to explore that. There are significant case reports, for example, in the Netherlands, in complex diseases, where a second assessment by a MAID assessor specialized in the condition that the person had discovered that a person who had been suffering for 8 years was giving up on life, has a second assessment, reassesses the person and says there is a misdiagnosis. They found treatment, the person's desire for a MAID dropped.
I mean, I think what is abundantly clear here is that the balance that has to be struck is incredibly delicate, incredibly frustrating as well. I hear that, but Jason, we're gonna have to leave it there. Thank you very much for your question. Our next question comes from Ron. Can I divulge your age?
Absolutely.
Is that okay? Yeah. Ron is 80 years old, but I will allow him to pick up the story from there. Tell them about yourself and what your question is.
I'm very pleased. I'm pleased to have this opportunity. It's an extraordinary chance for people, ordinary people in Canada, to talk about a very serious issue. I have dementia. I was assessed 4 years ago. Unfortunately, Minister Lametti, when the bill came down in 2016, MAID was constructed to be a failure. And it failed people like me. Why did we limit or take out any consideration of people with dementia? The way it was set up, we couldn't possibly apply. There are over 500,000 people today assessed with dementia. When they were assessed, they were the same the day after they were assessed as they were the day before. But somehow we've got a social construct that is in there that seems to think that once you're assessed with dementia, you become completely incompetent and incapable. We have 10 to 15 years in which I can make a decision as to when and how I want to die. Will people with dementia be included in this review we have coming up?
In 2016, when the first legislation came out, I was losing my mother to dementia. And so I understand the personal dimension of it, and I understand the question. Yes, we were supposed to look at dementia, other forms of cognitive decline in the review.
Right, because when you talk about this particular bill, I mean, it's been expressly excluded. I mean, like people for whom their sole underlying medical condition is a mental illness. And a lot of people are asking the question, why?
We heard around the table again and again and again, particularly from MAID providers, medical health professionals, that we weren't ready yet as a society. Let's leave this complex question for the summer review.
Trudeau, I'd like to have you kind of jump in. I mean, there is a careful balance here.
Mm-hmm. I think the dilemma is really that Ron and other people who have dementia are afraid of what will happen to them when their cognitive capacities have declined so much that they are no longer necessarily the same person, that they have different interests, different pleasures, that they may no longer be capable of easily communicating about their wishes, and that they then would no longer have access to medical aid in dying. I think that's really your concern. The Netherlands is the only country that allows it, and it has created significant tensions because people have developed different interests. They're still with us, but they no longer fully understand what will happen to them, why is somebody sitting them down to end their lives. So I think that's the real dilemma that we have, that we're struggling with.
We will have to leave that part of the conversation there, but Ron, thank you so much for your question. I really appreciate that. Thank you very much. Let's meet our next questioner.
Hi, my name is Phyllis Fair. I was diagnosed 7 years ago with early onset Alzheimer's. I have an amazing life filled with wonderful family and friends. I'm still very involved in advocacy work for people living with dementia, including human rights. I host an online support group on Friday for people living with dementia. It's a peer-supported group through Alzheimer's Disease International. And the rest of the time, I enjoy being with family and really spending quality time with them.
Phyllis, what's your question?
Okay, so I am going to read my question. I'm a person living with a cognitive impairment, and I want to make sure that I get this question out properly. So once I reach a certain age or a certain stage of Alzheimer's, I will consider MAID as an option. My question is, if I qualify for a medically assisted death but eventually lose my competency over time, how will the medical system ensure that there are enough safety checks in place to ensure I will receive MAID when I'm in need near death and not too soon before I'm ready?
Minister Lametti, I think that's a question for you.
Well, thank you, Phyllis, for that question, and thank you for all the work that you do. Dementia is difficult. Alzheimer's is difficult. They're difficult, complex questions. For the time being, we are putting those questions to a larger parliamentary review that's supposed to begin in the month of June. What we heard for now was that it's still really tough. A number of Canadians like you in the online consultations, as well as around the roundtables, certainly would like to see that right extended. We also heard from other people around the table, in particular in the medical profession, and that they're uncomfortable at this stage, and so we're going to look at it more carefully. It needs more work.
I mean, this does, Madeleine, sort of strike at the core of what makes this process so difficult and so taxing.
Specifically to your question of what will protect you, I would say not to forget that the assessor and the person who provides MAID to you eventually has a large role in respecting those safeguards, whatever they will be. And what I clearly have heard from other providers is that dementia is actually, when somebody loses competence to consent, comes the closest to bringing a provider to understanding the perspective of somebody with conscientious objection. Most would say they agree with it, you should be allowed to be approved, and then when you're no longer competent, receive it. They probably would want that themselves, but they would struggle to go in and provide it to a patient who, even if they met all the checklist of what they put down, seems perfectly happy. So I think that partly trust that your provider will assess that. The other thing I would say is to trust that your family members will help them decide when is right for you. I hope with the legislative review that you will consider that substitute decision makers or power of attorneys can play a role in making the decision of when.
How many people living with disease are being included in your review? Or are we allowed at that table?
Well, we do our best. I hope that in the parliamentary review that voices, there will be time and space for voices to be heard.
Wonderful. Phyllis, thank you so much
for
your question. Our next question comes from Glenn Johnson, who's here from Ottawa. Glenn, take it away.
Thank you, Andrew. I suffer from chronic pain, but I also have mental health issues and suffer from PTSD. Pain is pain, suffering is suffering. There's no foreseeable end to either of my chronic pain or mental health issues. Why are people like me not able to access MAID?
We know that mental health issues are serious medical issues and that the pain that's caused is serious, the suffering is intolerable. I think the short answer is we had meant to study this more deeply starting in June of this year. And we heard around the table that, particularly from medical health professionals, that it was so complex that we just weren't ready yet.
But it's also a right, a human right, and a right to choice.
I know that, and we're going to push pretty hard because of that. And we need to get to that answer as soon as we can.
I feel like the one answer you'd like to get is, so what's the timeline, right? When does this plight become the issue that gets solved in the forthcoming legislation?
Yeah. Well, we're starting it right now, which is great. And one of the good things about the consultation that we've done now and the work we did in 2015, 2016 as well, it got people to begin to think about it. And society's come a long way with respect to mental health in the last decade. But I can't promise a timeline. I can only promise to do my best as long as I'm in this role to push this discussion forward.
Susan, where do you sit on this?
We are very concerned about the exclusion of individuals with mental illness. I'm glad to hear that that would be considered in the review, and I think it has to really be seriously considered because the rulings so far have made it very clear that you cannot exclude groups of people based on their diagnoses. and that could be found to be unconstitutional, infringing their rights, and further stigmatizing those individuals. So we really need to hear from individuals with lived experience, and we need to hear from professionals as well to determine how we can do appropriate assessments on a case-by-case basis, where whatever their pain and suffering and condition may be.
Madeline, what is the way forward on this issue?
You know, I agree that suffering is suffering, and that it contributes to stigmatization to exclude mental illness. But I also agree that it's extraordinarily challenging. How do we know whether a request is a rational request, or is it partly driven for irrational motivations? How do we separate suicide from a mental illness from a rational request to die? It's been almost impossible to distinguish because they both have rational and irrational reasons for wanting to die. And what it's taken, I've got several case examples where what it's taken is them accepting treatment for the depression. And after the depression is cleared, it becomes clear to the provider what the basis of the request was. And I've had patients who changed their minds after and patients who didn't change their minds after. That's why we need the research.
Glenn, thank you so much for your question. I would like to take this opportunity, of course, just to remind all the folks who are listening to these stories being shared on very difficult subject matter that there is help if you feel that you need someone to talk to. It's out there. You can call or you can text Crisis Services Canada, or you can visit them online. Okay. Our next question comes from Sarah Jama. She's an organizer with the Disability Justice Network of Ontario. Sarah, you've got the mic.
Thank you for having me. I want to know, with the removal of the foreseeable death portion of MAID, how we will make sure that this access to MAID won't disproportionately impact Indigenous and racialized communities who feel as though they're not being structurally supported to live fully sustained lives. How are we going to make sure that these communities don't feel pressured to access MAID because they feel like burdens on the state?
Thank you, Sarah, for that question. The social determinants of a person's condition are critically important, and we heard that time and time again in the roundtables, including a roundtable specifically aimed at Indigenous people, Indigenous service providers. And so if MAID is going to work, it has to be a choice, an informed choice, and it has to be a choice amongst good alternatives, or at least amongst the least worst alternatives, in the sense that we need to work on the conditions in which people live, so that if they do make the decision to get MAID, it will be because it's the right decision.
I still don't really understand how you build into the legislation, build into the MAID infrastructure, some kind of way to mitigate this concern, that in lowering the barriers, you are perhaps opening the door to those who are most vulnerable. And maybe it is those folks who will disproportionately be asking for this.
So the International Rapporteur on the Rights of People with Disabilities just issued a report last week in which she stated explicitly, disability, chronic illness should never be a basis for facilitating, in other words, promoting by the state access to premature death. This is actually what the new law will do. And I see, as a scholar, that there are attempts to introduce safeguards in terms of that there has to be a 90-day waiting period, that physicians have to provide information about the available resources, and that they have to look at whether the person has seriously considered alternatives to having their lives ended. 90 days is nothing to turn people's lives with a serious disability or a very chronic illness around.
Sarah, thanks so much for that. That was an excellent question. Cheers. Our next question comes from Ernest Fredrickson. Have a listen.
Hello, my name is Ernest Fredrickson. I'm 27 years old and I live in Redwater, Alberta. I've been in constant, unending pain for over 11 years, primarily due to fibromyalgia, with additional pain due to arthritis, gout, and inflammation in my knees. I first applied for medical assistance in dying on June 7th, 2016, and was denied due to the fact that my death is not reasonably foreseeable. I will once again be applying to access MAID as soon as the law is amended. My question is, why should I, or those like me whose deaths are not reasonably foreseeable, have to continue, as Bill C-14 states, enduring physical or psychological suffering that cannot be relieved through a 90-day waiting period instead of a waiting period of 30 days.
So, Ernest couldn't be here today, but Minister Lametti, I think this is a question for you. And this is someone, another person for whom the forthcoming changes in the law, he has hope that his request for MAID will be reconsidered, will be fulfilled in light of the relinquishing of this criterion that death not need to be reasonably foreseeable. Right. But he's asking about that 90-day assessment that you mentioned. Seems onerously long to him.
Right. And again, I'd thank Ernest for the question. It's precisely for people like Ernest that we have extended the possibility of MAID in this current legislation. The 90-day period is meant to be a period of assessment, so it's not a waiting period. There were waiting periods under the old Act. We've actually eliminated them because we found that an additional reflection period or waiting period only prolonged suffering. People weren't taking their medication, that sort of thing, in order to maintain a clear mind to make the final decision. We've eliminated all of that. This is a period in which the relationship between the doctor and patient is critically important. That the doctor has an obligation to raise other possibilities of treatment, other possibilities of support within that time period, have the two assessments, and then make the decision. But once that decision's made, the decision's made.
But, well, Susan, maybe I'll have you jump in, because, I mean, it is expressly written, though, in the changes to the legislation that the assessment is not to take less than 90 days, even if the actual assessment itself takes less than 90 days. From your point of view, is there merit to having that period be as long as it is?
Well, I think I'd come back to the original decision where the justices of the Supreme Court talked about the cruel choice. And I personally, and our organization, is concerned about the length of this period of assessment because the individual who is applying for assisted dying, by definition, is already enduring intolerable suffering. Right. So I think it's really important to hear from people like Ernest, to speak with, for instance, assessors and providers who are members of the Canadian Association of MAID Assessors and Providers, and look at, do we really need a 90-day period, or is some other length of period reasonable to achieve the goals that we're trying to here in terms of balancing things?
Let's get to our next question.
I'm Bob Davis. I'm a pastor. Being blessed. Let's pray together. Many people in our churches, they do all the things of trying to put together things like hospices, or they give their lives vocationally to caring for the sick and the suffering. That's right in the middle of what it is to be a person of faith.
All of us have moments where there's suffering.
We end up caring not only for people at critical moments in their life or in loss, we also care for caregivers. It's quite complicated for them when they're asked to participate in something that they do not believe is okay. We need a society where people are free to live according to conscience. And we don't want to get in a situation where some people are able to exercise their freedoms only at the expense of someone else's.
We say amen. Amen. Bless you guys.
Hi, Bob.
Greetings.
What's your question?
Thanks for doing this. Duress, I think, damages the soul. And so my question is, what's being done? What steps are being taken to offer protections for organizations and for healthcare workers, for caregivers, for others who are vulnerable to all the psychological and emotional consequences of participating in a medically assisted death when it is against their conscience?
Well, I can tell you at the federal level, I mean, we work, as is the case with this legislation, with the criminal code. Nothing in this act, nothing in the 2016 Act, nothing in the current Act compels anyone to participate in MAID if they have any objection to it.
They have to give a referral to a physician.
That's provincial in terms of the way the healthcare system runs, and it's true that will vary from jurisdiction to jurisdiction, whether they have to give a referral or whether they feel that they're giving an effective referral. The Ontario Court of Appeal has recently ruled that patients have, in a sense, a right to have a referral or are better served by a referral, and maybe that will be the determinative idea that we do want patients to have service within the medical system. But nothing in this act compels anyone to participate. That's all at the provincial level or the local level. But certainly nothing in the legislation compels anyone, Bob, to participate when they don't want to.
Well, Madeline, I mean, you have sort of frontline experience when it comes to this. I mean, I'm just thinking of Bob's question about supports. What supports are there for people who are on the front line?
So I think your question, though, was supports for those where MAID goes against their conscience, which I completely agree with. And I developed the processes at the University Health Network in Toronto. And that was a priority for me, to make sure that nobody was required to participate in MAID if it went against their conscience. Thank you for being concerned about the caregivers. I think that's very valid. People were initially very concerned about the MAID teams, the people actively, directly involved in MAID. And what we found is that group actually doesn't need that much support because it's not against their conscience. And MAID is probably extremely poignant and some of the most meaningful work that we do. And initially, we put in place debriefs after every case. And the debriefs consisted of social work and spiritual care and bioethics. Psychiatry was there, and we gave staff the opportunity to just share their thoughts. The debriefs were very important initially. And again, what I found mostly was that the distress was not around how patients die, but just the death itself. Healthcare workers actually are quite used to that. And over time, we've needed fewer and fewer of these debriefs as it's become standard care. Family caregivers are a whole other issue. And there are resources out there for family members whose loved ones have gone through MAID.
Bob, thank you so much for your question. Thanks so much. Thanks. Okay, I'd like to get to our next question now. This is Dr. Dasani.
Hi, my name is Dr. Nahid Dasani.
How are you doing?
I work as a palliative care doctor. My practice especially focuses on communities who are vulnerable, including those who are homeless and countless more who are at risk of homelessness.
Our experience is that the homeless,
through a program called PEACH, Palliative Education and Care for the Homeless, a mobile, street and shelter-based palliative care program that puts our team on the front lines of the homelessness crisis and opioid overdose crisis. I'm particularly interested in today's discussion around equitable access to palliative care.
Immense work that you do.
Thank you.
What's the question you'd like to ask?
While I appreciate the importance of discussing medical assistance in dying at this time also presents a unique opportunity to talk about the benefits of palliative care during all stages of an illness, not just at the end of life. And I do want to remind everyone in the room that the WHO has recognized palliative care as a human right, and we still live in a country where the vast majority of Canadians do not have access to palliative care.
I agree with you. We need more palliative care resources. But it's not, for MAID, it's not an either-or situation. It's actually both and. We know from the latest report out of the coroner's office, there was a paper recently published that showed 75% of people who receive MAID also were receiving palliative care. So it's not an either-or.
Trudeau, what are the considerations?
I think it's a question of prioritization. It's clear that the priority should be on the right to health care, the right to have access to adequate care. That medical aid in dying in any jurisdiction that introduced it, and there are not so many, that is seen as an exceptional measure to facilitate a transition between life and death. We're now expanding that in an area where decision-making is very complex. So all of this makes me concerned about, are we prioritizing indeed allowing people to live their life to the fullest possible with the best possible healthcare support, or are we seeing, for one reason or another, medical aid in dying as kind of a magical solution to suffering of life?
And Susan, I mean, this push and pull is core to everything you've considered.
Well, our mission is to improve the quality of dying, and that is not limited to assisted dying. It's improving quality of dying, including access to palliative care. And if I can be a little personal, I have had the opportunity to accompany a family member through treatment, and she had accompanied her spouse through ALS, and for years had said to me, I am not dying that way. So she had the opportunity to request an assisted death, and for her, it was the right decision and the right choice, and gave her back some of that control over how her life ended, and made it a much better death for her and for those of us who accompanied her.
Thank you for your question. Thank you very much. Minister Lametti, I'll give you the opportunity for a final thought here, just in terms of everything that you've heard today. And I know over the years you've heard a lot from many different Canadians. But from what you've heard here today, what do you take away?
I think what you've heard today is representative of what I've heard in the consultations that I've done. There are a number of incredibly complex issues, a number of really touching and oftentimes tragic stories. And we're doing our best to reduce suffering as quickly as we can by moving through the various processes, in this case, Bill C7 in the summer, this legislative review. And the other thing I would add is the real sense of devotion and responsibility that you see amongst the medical profession, MAID service providers. We have really avoided a number of I think, really negative scenarios because they've been so responsible in the way they've applied the legislation. It hasn't been perfect, and we saw court proceedings because of it, but we're trying to correct it. We're trying to move with Canadian society and really reflect in what we're doing what the values of Canadian society are.
As we've heard today, medical assistance in dying, it is profoundly complex, it is deeply personal, and it is so, for so many people, for so many families across the country, it is this big, outsized, important, mammoth issue, and a conversation that we could only really begin to do justice here. So a big thank you to our panelists, Justice Minister David Lametti, Dr. Madeleine Lee with the Princess Margaret Cancer Centre, Trudeau Lemons from the University of Toronto, and Susan Desjardins with Dying with Dignity. Coming up, we ask our questioners how they felt about their experience. Were they satisfied with what they heard, and did they get the answers they needed?
Okay, Ron, what were your impressions of today's town hall?
Well, I was extremely pleased at who was there and why they were there, and I think it's about time we can get the door open on some serious revision of MAID. There are over 500,000 people today assessed with dementia. I was reaching beyond them to explain to the world there are a lot of people with dementia out there that have been denied and are being denied a chance to exercise their rights as a Canadian. Will people with dementia be included in this review we have coming up in June?
Yes, we were supposed to look at dementia, other forms of cognitive decline in the review.
Anybody who is facing this forward-thinking life that's full of pain and agony can choose MAID if they wish. It's a choice. It's a personal choice. And that choice can be made while they are cogent and fluent.
Let's leave this complex question for the summer review.
My questions were not answered. I wasn't expecting to get an answer. I was hoping to get a door open, and I think we did that.
How we will make sure that this access to MAID won't disproportionately impact Indigenous and racialized communities. Overall, in terms of my specific question, I felt that the minister was ill-prepared to answer how MAID will disproportionately impact working class, racialized, and Indigenous people who feel pressured into accessing MAID because of a lack of structural supports around life.
If MAID is going to work, it has to be a choice, an informed choice. And it has to be a choice amongst good alternatives, or at least, amongst the least worst alternatives.
I want to hear from the minister what precautions he's going to take to make sure that people who aren't receiving supports to live full lives are not feeling like they have to eliminate their lives to not be burdens on the state.
Disability, chronic illness should never be a basis for facilitating, in other words, promoting by the state access to premature death. This is actually what the new law will do.
What I heard in response to my question was that there's no intent to have people with disabilities or people living in poverty or racialized or indigenous people access MAID because there's no other supports. So I'm glad to hear that that is a concern that the government has as well. What I want to hear is the plan to address this concern before these changes around the elimination of foreseeable death are put into place.
With this criteria, even with the proposed amendments, you're still not giving the patient the ability to say for themselves, can I have a medically assisted death? The government is still saying, well, hold up, no, you can't.
I was hoping to hear something different than what I heard. The responses that I received from the panel to me were almost paternalistic.
You have to understand that medical aid in dying is a radical departure from normal treatment. So it means the end of the existence of the person.
The way that they assumed that a patient like my common law, like Justine, can't decide for herself a medically assisted death. They seem to think that they know better than she with regards to her condition.
I can't work, I can't have fun, I can't barely leave the house.
Seeing Justine's experience shared on screen and with the panel to me was very difficult because I know how much this means to her, and I knew that she wasn't going to get the answers from this that she wants. And it's tough for me to sit there and to essentially just be a witness.
Duress, I think, damages the soul. It's really good to feel that the openness was there to participate, and that both the minister and others are trying to include a range of people in their decision-making process. That's helpful.
Nothing in this act, nothing in the 2016 Act, nothing in the current Act compels anyone to participate in MAID if they have any objection to it.
I think I heard them answer that individual conscience rights are protected, but what about when we act together, when we participate in an organization?
Healthcare workers actually are quite used to that. Family caregivers are a whole other issue.
There's things I'd love to go deeper on, but I do feel encouraged that at least there was space for a perspective like mine to be in the room at the table alongside all these other diverse perspectives that need to be heard.
I watched my mother die a slow, painful death. Will or when will the MAID be available to a power of attorney to make those decisions?
We still aren't at the stage where power of attorney will be able to be used, but it is something that could be considered down the road.
I'm a little disappointed that this hasn't changed. I feel that we need the power of attorney to have these rights to MAID. I'm hoping in the future that will change. I know it's too late for my mom, but I hope it's not too late for others in the future.
This time also presents a unique opportunity to talk about the benefits of palliative care.
It was really important to hear from Canadians from all walks of life about their perspectives on something that is truly so complicated and impacts people during such a special and vulnerable time in their lives.
Our mission is to improve the quality of dying, and that is not limited to assisted dying. It's improving quality of dying, including access to palliative care.
I'm really inspired and hopeful about more conversation that will dive even deeper, particularly because this is something that impacts so many people, and particularly at such a vulnerable time, a special time in people's lives.
I agree with you. We need more palliative care resources. But it's not, for MAID, it's not an either-or situation. It's actually both and.
I still feel that palliative care is a very important topic that maybe deserves more dialogue in the discourse around medical assistance in dying, and particularly equitable access to palliative care when so many Canadians are clearly lacking it to begin with. But I was happy to be here today to at least present that voice.
How many people living with disease are being included in your review?
So I think today went very well. There was a lot of great questions asked of a very knowledgeable group of panelists.
I hope that in the parliamentary review that voices, there will be time and space for voices to be heard.
What it did do for me was let me know that there's still an awful lot of work we need to do on this topic, and it just reiterated to me that I have to get moving and I have to help make change.